Hi everybody, it's Attorney Brooke Goff. Happy Friday. I hear it's going to be an absolute beautiful weekend in Connecticut. I can't wait to come back. I'm in San Diego at a conference. I'll be back there so shortly. I can't wait. I love to do these pop-ups because, and there always is a pattern. I just don't wake up and say, hey, I want to do a pop-up. The typical pattern is that I get the same question over and over. And now with the radio show on 104.1 taking off, we're really getting a lot of comp questions. People know, not necessarily know, but they have an idea about car accidents. You can Google it. You can find, things that you want to get at. You can, figure out, okay, talk to the insurance company, set up your claim, everything else. But workers' comp's not that easy. You Google, if you look at different attorney sites, you'll get a different answer from most of them. Because I don't want to say there's no rules, but it's really, there's a lot of things here that's at the commissioner's discretion. You can have somebody with one issue in Bridgeport and somebody with another issue in Hartford, and the commissioners could rule exact opposites, where in court you don't find that, right? Because there's case law to follow, there's laws to follow, and everything else. So workers' comp, I get the most questions on because just people can't figure it out. And I got to tell you, just newsflash, most attorneys can't figure it out. So firstly, the biggest question I get is, I'm injured at work, now what do? I'm scared. Well, firstly, don't be scared. No need to be scared. If you're hurt at work, people get hurt at work every single day. No need to be scared about it. First, if your employer's near you, tell your employer. If your employer's not anywhere near you, you got to call for medical attention. If they're witnesses, have somebody call an ambulance. If not, then you call an ambulance. You got to get medical attention. You getting medical attention and reporting the claim to your employer, maybe the next day is not going to be that big of a difference. Especially if you're seriously injured, losing blood, that kind of a thing. I have many people that try to work through it until their employer comes, and it actually creates more of an injury. Don't do that. Don't make that mistake. Report it to your employer when you can, but firstly, get medical attention. Make sure when you go to the doctor, this is the most important thing I'll say in this, tell them it happened at work. So many times people go to the doctor and they say, hey, I got hurt. What happened? And they don't want to say that it happened at work, and they're scared to because they're afraid that their employer is going to retaliate. Don't, because if you do that, I've had many cases, I just settled one, and it took a year longer than it should have, where the man was just scared. He was not a citizen. He was scared. He didn't want to report it. So he didn't. Right? He just said, hey, look, I got hurt at home. Well, guess what? He didn't. He got hurt at work, and thank God there was a witness. And but we had to, now his credibility is questioned because he was not honest with the doctors. And it just created this, he had to have his deposition taken. We had to take depositions. It created this big, huge problem that did not even need to exist. Had he just said, I was hurt at work, this is the deal. Insurance companies look for anything they can to deny your claim. Always. Every single time. So if you're not honest in your reporting, you're going to be buying yourself trouble, significant trouble. So let's say you went to the doctor, urgent care, clinic, wherever you went, and you have an injury, and then you reported it to your employer. Your employer doesn't file a form called a 30C. The insurance company for your employer files what's called a first report of injury. You have a duty to file a 30C within 1 year. The form's online. Go online. Just type in Workers' Comp Connecticut. They'll take you to the site. And just FYI, if I hear I'm looking down, it's just the angle of the phone. So I'm not looking at anything in particular. To me, it appears I'm looking at you guys, but if I'm not, my apologies. I don't have my tripod here. So the 30C is the first form to be filed. All right. It is a form you can find online. It has to be signed by you, and it asks, who your employer is, what your information is, when the injury happened, and what are the injuries. Be as specific as possible. All right. If you have a really bad back injury, your neck is hurting just a little bit, you think it's getting better, put both, because then they're going to claim that you had a neck injury for the first time, 6 months, 3 months down the road, and then you're going to be facing significant pushback on that. So that's a 30C. My recommendation is you go down to Workers' Comp and you get one of the booklets within a few days of being injured if you're mobile, and you file the 30C once you're there. Then it's done. You have to certify it to the employer. You can't hand deliver it. It's got to be certified mail. Save that certified mail tag. I always tell people, put a letter with it just saying, hi, I've enclosed a 30C, and then put the number that you get on the green card, which I'm sure the post office can help you with. on the letter, so that way you have a tracking, and you always have it so that you can track it online, just in the case they claim they never got it, because they have to receive it, and it's got to be certified, or it doesn't count. All right. Now, if you don't file a 30C within a year, it doesn't mean all bets are off. If they paid your medicals, or if they paid you lost wages, they're still going to probably fight, but you should be safe, because now you've filed a 30C, and they've already paid. So basically, a 30C is for notice reasons. So if they're already paying your medical and your lost wages, they obviously know. So they have a really hard time contesting that, but we see it all the time. Just file the 30C, get done with it. Next form to file is called a 1A form. That is your tax form, and it's with workers' comp. Again, when I'm at that 30C hearing, I'm filing a 1A form. Take that home with you, though. Don't give that to comp, because you're going to need it later. This 1A form is how we're going to determine that your benefits are being paid at the right rate. If you're potentially not being paid at the right rate, why are you going to find out 6 months down the road where they owe you money, then they're going to fight with you, then they're going to try to not give it to you, then they're going to drag it out? It doesn't make any sense. People ask me all the time, I'm not a citizen, can I file for workers' comp? Absolutely. If I file for workers' comp, is it going to make, ICE come in and get me? No. I mean, you have the right to file under workers' comp. Now, if I file for workers' comp, it's going to put me in a database so that ICE can find me. I mean, you have no better way of getting deported than through, just the regular means. Workers' comp isn't going to help that. If my employer pays me cash, right? Can I still file for workers' comp? Absolutely. They are very difficult cases. We do them. We've been successful at them. But yes, you can. How are you going to determine that I was an employee if my employer paid me cash is going to deny I was there that day? We deal with that. That's my problem. Let that be my problem. If you are illegal, there are some benefits you can't get under workers' comp that citizens can get. But for the most part, I settle these cases all the time. If you are not a citizen, it doesn't impact your right to file for workers' comp. And let me tell you, some of my most significant injury cases have come from non-citizens, unfortunately. Why? Because they're doing a lot of the manual labor and they're being paid very little. And it's actually very sad, but a lot of people don't do workers' comp because they're afraid of this being reported, being deported. None of that has anything to do with you filing workers' comp. So those are the initial paperwork to be. That is the initial paperwork to be filed. Can I be fired for filing a comp claim? I get this question every day. The answer is no. If your employer fires you for filing a comp claim, you have a wrongful termination claim, and they're actually probably going to pay you more under the wrongful termination claim than they're ever going to pay you under the comp claim. So hopefully they're not that stupid. They have been. I've done these. We do. I say we do well with these. We do well with these because there's punitive elements. They open the door if they fire you to a whole lot of significant benefits that you would not get. I hope, but let me just carve out a little thing here. So people also ask me, well, my employer, it's been a year, I haven't returned to work, my employer needs to replace me. Is that okay? Under comp, the employer has to take reasonable measures to have you keep your job or find an accommodation for you within the workplace, okay? So if you are a head chef and now they find a job for you as a sous chef, well, they're making reasonable, accommodations to try to assist you here. But again, they can't fire you just to fire you. Literally, if somebody came in my office and said, hey, look, I lost my job. They fired me for filing a comp claim. There's a questionnaire we do and everything else. But what ends up really happening is that the employer has to show us, hey, you said that you fired my guy because times were tough or whatever. Show me you fired other people too. Why'd you zero my guy out? And then they start getting nervous because of the workers' comp element. And let me tell you, most of the time it is. Question number 3, can I sue my employer? Yes and no. So let me explain that. First, workers' comp is the exclusive remedy for people hurt at work, meaning you can't sue your employer for negligence as a result of being injured at work, okay? However, if your employer was reckless, let me give you an example. You're a roofer and it's icy and you don't want to go up on the roof, and the employer says, go up on the roof and clean it off, and start working. You go up there, you slip and fall, you come down, you break your neck. Can you sue your employer? No, the employer wasn't reckless. It was stupid, but it's not reckless. Second example, the roof is icy, you're a roofer. You want to go up, you want to fix the roof. you can't. You say to your employer, hey, look, employer, I can't go up there. It's really dangerous if I go up there. Your employer says, I'll go up there with you. Goes up there with you and says, hey, dude, watch this, and pushes you, and then you fall, and then you break your neck. Yeah, you can sue your employer for that. That's reckless, wanton conduct. It's intentional conduct, okay? It's got to be intentional. Doesn't happen often. I've seen it twice. Not the roof example, obviously. I've seen it on a much lower scale, but I've seen it twice, and I can tell you that don't plan on suing your employer under workers' comp. Doesn't happen. Now, if you are in an accident, car accident when you're working, right, you have a comp claim. But what if somebody else caused it? Well, you can sue that third party that's not your employer separately, right? So we do this all the time. So that's actually a very good case scenario for you. So what would happen is you would sue, you would file your comp claim, then you would sue the person that was responsible for the accident, and your employer stays out of the third party action. Unless they have what's called benefits, which is underinsured motorist benefits, and then you can collect under that because that's not suing the employer. That's just submitting a claim under a benefit already owed to you. Why do I get less money in workers' comp? Well, so here's the thing. You do, but not by much. They use the tax guidelines. So let's say you gross $1,000. Actually, I can do it right now. You just stay with me. And again, I won't be looking at the phone. I'll give you an example. So a gentleman, let's just say he's single, and he makes $1,000 a week before workers' comp, okay? And he is injured to the point where he is not able to return to work. So if he makes $1,000 a week and he's single, his comp rate, and I have a system, it's called Comp Tools, and any good comp attorney has it. And if you go into a comp office, a comp attorney's office and say, hey, I want you to represent me, the first thing that you should ask is, what's my comp rate? Do you have Comp Tools? If they're not investing in Comp Tools, walk along, keep moving. So the comp rate would be $592.98. So yeah, I mean, it's out of that, just to let you know where some of the money is going. $91.14 is for federal. FICA is $62. Medicare is $14.50. Connecticut tax is $41.71. And then obviously you get the cut and the break. So $592.98 is somebody's comp rate for $1,000. The way it is, it's workers' compensation. I can't change that, but I can tell you that this is why, like, the extra benefits people aren't told about, mileage, be reimbursed for co-pays in the event that you had any, is so important, because I mean, people are getting this particular gentleman's getting 60%, right, almost of his income that he's probably used to getting like $720. So it's $120 a week. That's $480 a month. That's a lot of money. So that you get less money in comp because it's done by tables, and it's what workers' comp felt was fair and reasonable. Do I need to go to their doctors? So it depends. If you are like an employee contracted with Yale, contracted with like Harvard Healthcare, then they require you go to see their doctor at least once, okay? Which is fine, done. They also have a network of doctors you can choose from, which is pretty extensive, that you can go and see and treat with, all right? So that's also another piece of it. However, despite, like, let's put those employers aside for a minute. You get to choose your own employer. You get to choose your own employer too. You get to choose your own doctor. So if you're hurt at work and your employer says, no, you need to go see, John Smith. No, I get to choose my own doctor. The problem is if you go see John Smith because you're afraid that your employer is going to fire you if you don't, and you go to him a few times, and let's say you hate him, you've accepted that doctor now. Now you might not get the chance to choose your own doctor. Choose your own doctor. These doctors that the insurance company sends you to, or the employer sends you to, works for them. Why would you go to somebody that works for them? Their job is to mitigate damages and get you back to work as soon as possible, so the employer isn't paying an employee for not working. Stupid. Don't do it. Be smarter than that. Be smarter than the system. Be smarter than them. What is a rating? You get an impairment rating so let's say John Smith gets hurt today. In a year, 9 months to a year, he's going to get what's called an impairment rating, okay? And it's to the body part he injured or she injured in the accident. So let's say they injured their back, right? So if they're given a 10% impairment rating from their doctor, by and through a Form 42, right? That's going to equate to 37.4 weeks under the tables that you're going to be paid. So if you're making $1,000 a week, that's $37,400. Now, this all is going to sound really complicated. And if it sounds complicated to you, this is exactly the reason you should have an attorney. This is it. Because I can tell you that I'm just touching on like the easy stuff, and even the easy stuff is not so easy. There are a lot of pieces here I am not touching on that makes this process very complicated, impossible, and you're literally leaving benefits on the table. So again, my recommendation is always an attorney. I'm going to go through that in a second. But a rating, that's just a gist of what a rating is. Your doctor gives you a rating at the end of the case. That's all it is. And when your doctor gives you that rating, it has to be sent to the employer. The employer has the chance to get their own rating, right? If they choose. If they do not choose, then obviously they won't get their, they'll just accept your employer's rating. Sorry, it's early here, your doctor's rating. But you have 50% shot of that happening. Can I settle? Of course you can. But you cannot settle your workers' comp claim when you're still working there. What does that mean? So if let's say you continue working after you get injured, right? Let's just say you continue working for, if I reach my phone, it's because it's ringing. So let's say you get hurt 5 months after, let's say you continue working 5 months after you get hurt, okay? And let's say during that 5 months, you decide you want to settle your comp case. Let's say it's a smaller case, you want to settle it. You have to resign at the time that you sign the paperwork. Don't resign before, don't stop working before. It requires a resignation. So you can't continue to work at your job and settle. So I've had cases where I can settle somebody's case for $250,000, right? It's great. However, the person has a good job. They're working for, a good company where they're getting benefits and everything else. They don't want to resign. Fine, don't. You just can't settle it. But if I'm handling the case in my office, and let's say you're like, hey, look, Brooke, but in 5 years I'm retiring, or 3 years I'm retiring, fine, we'll settle at that point. You're at risk as long as you're on the dole, as long as the case is open. So there's usually a interest to settle down the road, but that amount of money that your case is then after worth is lower. Every year that goes by, the lower the risk that you're going to re-injure. So the number goes down, number being the settlement number. But I always tell people, don't leave your job for a settlement. It's stupid, unless you really just can't do the job or you're unhappy there. But if you love your job, I have people that work at Cablevision, these jobs, they give great pension, they give good benefits, a person's making $30 an hour. I say to people, don't leave your job just because you want to settle your comp claim. Keep it open. If you have a good attorney, the attorney's going to tell you to keep it open. It doesn't close. And let's say in 5 years you decide to leave, you retire. I don't know. They stop. They close. Whatever the case might be. Although Cablevision's not going anywhere. Then at that point we settle it. Okay. So these are like the big fire questions I've been given. However, how much do you cost is another question I get. Workers' compensation attorneys make 20% of your overall PPD and or settlement. And you might be confused by the and or, right? So 20% of so settlement usually comes in two pieces, PPD and then the rest of the benefits, okay? So PPD is actually part of your end benefits. And that's something that a lot of people don't get until they get us involved anyways. So my fee is 20% of the end game, okay? So I could represent you for 5 years, go to 100 hearings, not be paid a dime. You get all those checks the entire time. I get paid at the end, okay? So if I settle your case for $100,000, my office gets 20. If I don't settle your case for anything, but you collect checks during the time I represent you of $100,000, guess how much I get? $0. Why? I only get checks at the end game. People say, how do you make money that way? Well, a good comp attorney knows which cases are going to net a settlement and or PPD and which cases aren't. If somebody comes in my office, happens all the time, and says, hey, look, Attorney Goff, I hurt my ring finger, I think I sprained it. I tell them how to handle it themselves. Don't pay attorney 20% of what could be like $1,500 to do it. Just handle it yourself. It's not that hard. However, backs, necks, hands, shoulders, knees and toes, right? Knees, feet, ankles. These are the gifts I keep giving. There's other benefits associated with these. I always recommend an attorney that knows what they're doing. That's key. Don't go to an attorney where you go on their website, divorce, real estate, personal injury, workers' comp. Do you want to be the afterthought of the process? Personal injury and workers' comp, that's the attorney you want, all right? And also, when you go in there, ask, how many active comp cases do you have? I mean, I've worked with attorneys that hold themselves out to be comp attorneys, and they have like 40. That's not that many. And in fact, that's very low. And the more the comp cases that they have, it means the more experience and the more crazy situations they've seen, right? I have seen some significantly crazy situations. At any given time, we have about 400 active comp cases in the office. That's a lot of cases. But we have the staff to manage them and the attorneys to manage them. We have case management software. We have things that make our job easier than your typical, solo in an office that doesn't really have the tools. How many comp cases have you tried? That's another question you need to ask. If they haven't tried at least 3 to 5, I don't know that you want that attorney. I'm sure, here's the deal. If they work with somebody that's tried more, great. But formal, I tried a case. I've tried many more than one, but I tried a case in comp. We went to 8 formal hearings. The transcript is like this, literally testimony after testimony. And the problem is comp attorneys typically are not attorneys that are in court. What does that mean? So if they haven't tried a superior court case, so like a car accident, why is that important for you to know? Well, I walk into my formal hearings because most comp attorneys that are on the other side haven't ever had a trial. And so look at it like this. Workers' comp court is here, right? And then superior court's like here, just because of the rules and everything else. So if you could do this is like a cakewalk, right? So there's a lot of defense attorneys in workers' comp that have only done this. So if your claimant's attorneys up here, they're going to crush them, right? Because we know the rules of evidence. We know all these things. And it's fantastic. So I will tell you, you should definitely have an attorney that has superior court experience outside of workers' comp as well. I've tried a lot, double digits. And for my experience level, that's a lot. I've seen witnesses break down in the stand. I've seen people not show. I've seen people lie. I've seen my clients not show. I've seen all of it. And you got to know how to deal with all the situations. And if you don't know how to deal with the situations, you're not going to be able to best serve your client. All right. So, to get back to the question, that's how I get paid. I get paid at the end of the case, right? I will tell you my fee and always pays for itself and some. I have cases where people have come in. I have one right now, actually. Somebody came in. Their offer was $25,000. They were doing it on their own. I've had the case now probably 6 months or so. It was $25,000, right? And they said, I was on the fence getting a lawyer. I don't want to get you and then have you just like get the same and then me owe you. And I'm like, look, if I were only able to get you $25,000, I wouldn't. Why would you take a fee on that? You can't. You're not going to hire me. You're basically not going to pay me to hire me to take some of the money that you already got for yourself, right? So, anyways, we ended up, we didn't mediate that. No, we did. We mediated in front of the commissioner at workers' comp. It wasn't supposed to. It was a settlement conference. And we sold it for $92,000. So do the math. My fee on $92,000, I don't know what it was off the top of my head, maybe 17. My client's walking with 77,000. So that is almost 3 times what he would have walked with without my involvement. And that's after my fee. So that's what he walks with. He's thrilled. Everybody's thrilled. He's actually getting what the case is worth. Insurance. Once you sign those stip paperwork, people, once you sign on the case is over, you're not opening it. It's it. So if you think, okay, well, I'll do what I got to do now. I don't really know what I'm doing. And then maybe when I have time, I'll deal with a lawyer later. Do not. You sign a stip. It's over. I can't help you. I can't. So do the right thing. Consult with an attorney in the beginning. If you decide you don't want one, then that's one thing. But at least you educated yourself as to, okay, well, what are the benefits from having an attorney versus not? So that is my spiel. My recommendation, as always, is consult with a lawyer before you decide to do anything. Okay? Doesn't mean you have to hire them. Any good attorney is going to give you a free consultation. My office does. If you have a comp claim or you know somebody with a comp claim, and you want to have them view this video, share it. It's always great. Share it. Have them call me if they want. I'm happy to chat with them. Office number is 203-399-0000. My email is Brooke, BROOKE, @golflawgroup.net. And my clients text me as well, 203-913-4179. Continue following us on Facebook. If you found this video, you probably are already. Attorney Brooke Goff or Goff Law Group. And again, if you feel I'm looking down, it's just the angle of the camera. I promise you, to me, it looks like I'm actually looking straight on at you guys. And I hope these questions helped. If you share the video, I'm sure you're going to help somebody else because they're going to see this as well. We're probably going to boost this video, which means that we'll bring more attention to it. And if you have does anybody have any questions? I'm happy to help you with that too. You can ask over this, or you can just simply Facebook message me. You can text me. You can email me. I just give you my phone. And make sure going forward you listen to the radio show, because a lot of people call in with these exact questions. It's on at 9 a.m. on Tuesday mornings at 104.1. Enjoy the day. Enjoy the weekend. I guess it's going to stop raining there, and it's going to be absolutely gorgeous. And always, as always, if you're going in a pool, follow the signs and use safety. Thanks, everybody, and I will see you on Tuesday. Thanks.